Welcome to episode 19 of the Thoughts with Lakshman podcast. Um, in my podcast, I really focus on a wide range of topics, in German culture, and I really like to learn about German society, you know, systems that they have in place. For example, their educational system, the government, their political system, and comparing those systems to the United States, you can really learn something, and you can really see the differences and where they're similar. I also like studying history, and because it really helps you understand and put in perspective why we act the way we do in the present today. And yeah, I first started learning German as a foreign language. Um, and as I got deeper and deeper into my foreign language course, and I started my sophomore year, by the way, and as I got deeper and deeper, I started learning more cultural stuff as part of the course, and I became interested in it. So I started reading a lot. I started just learning more about it. And that's why I decided to create a podcast because I thought, I'm in a good position where I could really share my information. And I do it, as in my free time anyways. So, it, yeah, I thought it was a way that I could share, the topics and concepts and stuff that I just found cool. But yeah, in this episode of the podcast, we're going to be focusing on the German government. Um, just to reiterate, my podcast is available on all platforms: Spotify, Apple Podcasts. It's even on YouTube too. It's called the Thoughts with Lakshman podcast. And yeah, let's get into episode 19, the German government. So the structure and authority of Germany's government are really derived from the country's constitution, which is called the Grundgesetz, or the Basic Law. And this went into force on May 23rd, 1949. And this was really after, formal consent to the establishment of the Federal Republic. And the Federal Republic, by the way, was known as West Germany. And it had been given, by the military governments. This consent had been given by the military governments of the Western occupying powers. France, England, the United States, and upon the I guess you could say the assent of the parliaments, the states to form the the federation, really. And remember, in German, the word for states, I mentioned this in 3 or 4 podcasts, but yeah, Lande is the word for states, and the federation is called the Bund. So I might use those words in the future. So yeah, just it's good to know them. West Germany at that point in time really comprised of 11 states in West Berlin, which was given, the special status of a state without voting rights. And as a solution, really, until an anticipated reunification, with the eastern part of the country. The capital was located in Bonn, which was a small university town. And on October 7th, 1949, this was a pretty important date in history. So the Soviet zone of occupation, right, because they had the East, it was transformed into a separate, sovereign country, and it was known as the German Democratic Republic, and which is basically East Germany. And so this was really the day that the true difference and separation really happened. Now the 5 um, federal states, within the Soviet zone, they were abolished, and they were reorganized into 15 different administrative districts. You know, where the Berlin became the capital of the Soviet section, and full sovereignty was really only achieved gradually in West Germany. Many powers and prerogatives, including direct intervention, they were really retained by the Western powers and really devolved to the West German government, and only really as it was able to become economically and politically stable. And once West Germany achieved this, they got full sovereignty, and this happened in 1955. Now, East Germany, it regarded its separation from the rest of Germany as complete, but West Germany really considered, its eastern neighbor, you know, as an illegally constituted state until the 1970s, when the doctrine of, the two German states and one German nation was developed. Um, you could say that gradual, um, disagreements, between the two governments, helped to add on to the situation, especially concerning travel, transportation, and the status of, West Berlin as an exclave, of the Federal Republic. And the dissolution of the communist bloc in the late 1980s really opened the way to German unification. Now, really, as a condition for unification and its integration into the Federal Republic, East Germany was required, to reconstitute the five historical states, Brandenburg, Mecklenburg, Saxony, Saxony-Anhalt, and Thuringia. And as the states of the United Germany, they adopted administrative, judicial, educational, and social structures parallel, to those states, of what was, West Germany. And East and West Berlin became basically reunited, and they formed, a single state. With the country's unification, 1990, all parts of the Federal Republic qualified, as status um, for the sovereign state they were voided. Like, for example, Berlin was no longer technically occupied territory, with ultimate authority vested in the military governors. Now, Germany's constitution, it was really established as a parliamentary system of government that incorporated many features of the British system. But on one hand, though, the basic law or the German constitution, it created a federal system. Unlike the UK's, and many political structures were actually drawn from the model of the United States. Um, in reaction to the centralization of power during the Nazi era, the basic law granted the states, a lot of freedom, a lot of power. And in addition to federalism, the basic law has two other distinct, similar features to the United States. One, its formal Declaration of Human Rights, and two, the strongly independent position of the courts. Especially in the right of the federal constitutional court to void a law by declaring it unconstitutional. And the former chief of state is the president, and it's intended to be, an elder statesman of stature. The president is chosen for a 5-year term instead of a 4-year term, but it's not a full, election. It's he's chosen by a special assembly. And in addition to signing all federal legislation and treaties, the president really nominates the federal chancellor and the chancellor's cabinet appointments. And the president may dismiss, upon the chancellor's recommendation. Also, um, but the president is not as powerful in Germany compared to the president of the United States. The president can't really dismiss either the chancellor or the leaders of the lower chamber of the federal parliament. And then the president, another important presidential function is to appoint federal judges, which is another similarity to the United States, except that I don't believe there is a Supreme Court in Germany. uh, there's probably a highest court, but they probably have an equivalent to it, but I think the name is different. But yeah, the president also has to, in Germany, has to appoint federal judges, and other officials, and he also has the right to pardon and reprieve. Now, the government is headed by the chancellor, who was elected by a majority vote of the Bundestag, or Congress, German Congress, and upon nomination by the president, and vested, I guess you could say, with considerable independent powers. The chancellor is the one who's responsible for initiating government policy. The cabinet and its ministries also enjoy extensive autonomy, and powers of initiative. But really, the chancellor can be disposed only by, an absolute majority of the Bundestag, and only after a majority has been assured, for the election of a successor. And this constructive vote of no confidence, in contrast to really the vote of no confidence employed um, in most other parliamentary system, which only requires a majority, opposed to the sitting leader to get rid of them, reduces the likelihood that the chancellor will be unseated. And the constructive vote, of no confidence, it's been used, only once ever to remove a chancellor from office in German history. Now, the cabinet may not be really dismissed or dissolved by a vote of no confidence by the Bundestag, and the president, may not unseat a government, or in a crisis, call upon a political leader at his discretion, to form a new government. The latter constitutional provision is really based on the experience of the sequence of events, really, when Adolf Hitler, became chancellor, and that's also very. He really had a profound. He had a really uh, massive, I guess you could say, impact on how Germany viewed their government system after that, because they were like, how did we let someone like him get so much power? And they made changes after that. Um, and hopefully, nothing ever happens like that again. And that's the reason, got um, majority of countries aren't dictatorships, because if one person has all the power, it's very, very dangerous. And even though Germany has a democracy and did have a democracy um, at the time, um, it shows the flaws in the system. The fact that Hitler was able to get into power, and they've adjusted, and they've made provisions. They made constitutional provisions to really learn and move on from that. Most cabinet officials, are members of the Bundestag, and they're really drawn from the majority party, or proportionally, from the parties forming a coalition. But the chancellor may actually appoint persons without party affiliation, but with a certain area of technical strength. So I mean, I guess this, you could see this in the United States in some cases, but people are appointed to the cabinet who are really, supporters and who stand within party lines. But in Germany, it's more common. And part of the reason is that they're more political parties. So if someone comes from one party and there's another party that like agrees with a lot of the same stuff but disagrees on a little, um, you can see people from different parties being appointed to the same cabinet. Part of the reason is you just want the strongest people at whatever their niche little area is, whatever they have to do, whether it's education or defense or homeland security or whatever. Now the Bundestag, which consists of 600 members, um, and this precise number, varies depending on election results. The Bundestag is really the cornerstone of the German system of government. It exercises much wider powers than the 69 member upper chamber, which is called the Bundesrat. The Bundesrat delegations, represent the interest of the state governments, and they're really bound to vote, unanimously as instructed by their government, their local governments. All legislation, really originates in the Bundestag, and the consent of the Bundesrat is really only necessary on certain matters directly, affecting the interests of the states, um, especially, in the areas of finance and administration, and for legislation in which questions of the basic law are involved. It may restrain the Bundestag by rejecting, certain routine legislation passed by the lower chamber. But unless a bill falls within certain categories that really enable the Bundesrat to exercise an absolute veto over legislation, its vote against a bill really may be overridden by a simple majority in the Bundestag, or by a two-thirds majority in the Bundestag, should there be a two-thirds majority opposed in the Bundesrat, if that makes sense. So, to amend the basic law, you know, however, this is a little different. You need two-thirds vote in each chamber. So you can tell, right? It's not really that easy, and it's purposely, not easy to get stuff done in terms of votes and stuff. Um, and there's a similar system of checks and balances, not on the same scale as the United States, in a slightly different way, but the concept is still definitely there. Now, the powers of the Bundestag, they're kept in very careful balance, with those of the state parliaments, and certain powers, are specifically reserved to the republic. For example, foreign affairs, defense, international trade, matters affecting citizenship, and the Bundestag and the states, they may pass concurrent legislation in such matters when it is necessary and desirable. Or the Bundestag may set out certain guidelines for legislation. Drawing from these, each individual land, which is a state, may enact legislation in keeping with its own needs and circumstances. But really, in principle, you could really say that the Bundestag initiates or approves legislation in matters in which really, uniformity is essential, and the Landtage, are otherwise free to act in areas which are basically not, expressly restrained by the basic law. And that's similar to the Constitution, right? It basically gives all powers not listed for the federal government to the states. And that you can see that in U.S. history, with the Louisiana Purchase, because you had Thomas Jefferson, who was a big believer in a strict interpretation of the Constitution, and he really believed in limiting the power of the central government. And when the opportunity came, to buy the Louisiana Purchase, he was very concerned, even though it was a fantastic opportunity. Because what happened was the United States first offered 10 million for New Orleans because they were concerned. They didn't want New Orleans was a very strong city, and they wanted to help out the people moving west and with their trade in New Orleans. So they offered 10 million for New Orleans and to France, because France owned it at the time, and France was fighting a war with Britain. And Napoleon said, "Give us 15 million, and you can get the entire Louisiana Purchase." So the U.S. guys, the diplomats who went to negotiate, they were like, "Whoa, that's a great offer," and they were really strongly considering it. And obviously they ended up doing it. But Thomas Jefferson was concerned because the federal government wasn't explicitly allowed to buy land in the Constitution. So he tried to pass an amendment before actually doing it, because he was such a strict believer in the Constitution. But he would have risked not getting the deal done, so he just did it. But it's in that way. It's that example demonstrates a similarity between the basic law in Germany, because it gives the states all the powers that the federal government doesn't. It's not listed for the federal government in the Constitution, and it also explicitly limits the federal government's power. Um, But yeah, let's focus now a bit more on regional and local government. So certain functions like, education and law enforcement, they're expressly, the responsibility of the states. And, although there is an attempt to maintain a degree of, uniformity among the 16 states, through joint consultative bodies, the state governments are generally parallel in structure to that of the Bund, in certain ways, but then in others are not. In 13 states, the head of the government has a cabinet and ministers, and each of these states also has its own parliamentary body. In the city states of Hamburg, Bremen, and Berlin, the mayor serves simultaneously as the head of the city government and the state government, which is interesting. In the city states, the senates serve also as parliaments, and the offices, assume the nature of ministries. And the administrative subdivisions, really, of the states um, is very interesting. These divisions are known as Kreise or counties. Larger communities enjoy, what's known in the UK as a borough. The counties themselves are divided into communities or Gemeinde, and these communities, through a long, German tradition, have achieved, considerably, have really achieved considerable freedom and responsibility, in the administration of schools, hospitals, housing, construction, social welfare, public services, utilities, and many other things. And voters may pass laws on certain issues, through referendums, at the municipal and state levels. In terms of the justice system, the German court differs from the United States in that all the trial, courts are state courts, while the courts of last resort are federal. Um, all courts may hear, cases based on law enacted on the federal level, though there are, some areas of law where the states have exclusive control. Now, the federal courts, assure the uniform application of national law by the state courts, and then on top of that, the courts of general, jurisdiction for civil and criminal cases. The highest of which is the Federal Court of Justice, which is, I guess you could say, the the German equivalent of the Supreme Court. And there are four court systems, with specialized jurisdiction, in administrative, labor, social security, and tax matters. And the jurisdiction on the three-level system, of administrative courts extends to all civil law, of a non-constitutional nature, um, unless other specialized courts have that jurisdiction. Now, although all courts have the power and the obligation to review the constitutionality of a government action and legislation within their jurisdiction, only the federal constitutional court, may declare some sort of government legislation unconstitutional. Other courts, if they wanted to do so, they must suspend proceedings, if they find a statute unconstitutional, and they must submit the question of constitutionality to the federal constitutional court. Um, in serious criminal cases, the trial courts, sit with lay judges similar to jurors who are chosen, by a lot from a predetermined list. And the lay judges, decide all questions of guilt and punishment jointly with the professional judges. And lay judges also participate, in some non-criminal matters. Now, judges on, the federal constitutional court, they're chosen for non-renewable 12-year terms, which is different, right? In the Supreme Court, once you're appointed, you serve for life. The until you resign. Um, the Bundestag and the Bundesrat, they each select half of the court's 16 judges. In each case, the nominee must win with two-thirds support to secure appointment. The court sits in two 8-member senates, and they handle ordinary cases. and then important cases are decided by the entire body. Now, judges really play a more, you could say, prominent and active role in all stages of legal proceedings, than really, their common law counterparts. And, proceedings in German courts tend to be less controlled by prosecutors and defense attorneys. There's less an emphasis on the formal rules of evidence, which, in common law countries is largely a byproduct of the jury system. And there's more stress on letting the facts speak for what they may be worth, in the individual case. There's no plea bargaining in criminal cases. In Germany, as in most European countries, litigation costs are much, much less than those in the United States. But the losing party, in any case, usually pay the court costs and attorney fees of both parties. Now, although codes and statutes they're viewed as the primary source of law in Germany, precedent is of great importance in the interpretation of legal rules. So, for example, German, administrative law is basically case law in the same sense that there's no existence of principles relied upon, in the process of reviewing administrative action. These principles are mostly the law as determined by previous judicial rulings. So Germans really see their system of judicial review of administrative actions as, implementation of the rule of law. So in this case, really, an emphasis is placed on the availability of judicial remedies. Now, unification brought about, the integration and adaptation of the administration of justice of East and West Germany. But this was complicated by, the large number of judges who were incapacitated by the Union. And many judges were dismissed either because they owned their appointment as judges, primarily to their loyalty, to the communist government, or because of their records. And that created a system where justice was not always fulfilled. Now, to fill, the many vacancies created in these courts as a result of that system, judges and judicial administrators were recruited from former West Germany, and many, urged others out of retirement to solve this crisis. But but really, that's really a side point. The main takeaway is that there's in Germany, there's a big emphasis on how courts ruled before. That's how we should rule now. Um, there's less formality, less costs in court. 12-year terms. And in terms of that's the justice side of things. That's just a recap there. In terms of government, lots of power for the but really in terms of government, there's lots of power for state governments, like there is in the United States, and there's a basically a Bill of Rights. They explicitly declare all the rights that humans have that or citizens have that can't be taken away, and the government also gives all power not explicitly listed for the federal government to the state government. So that's another similarity. But yeah, thank you for listening to the podcast. I hope you enjoyed. I'm gonna be working on many more in the future. Right now, this is episode 19. My goal is to really get to around as many as I can. I try to do one a week. Research for the podcast does take some time. But yeah, I really enjoyed, and I hope you enjoyed listening to the podcast. Thank you, and goodbye.